Hi everyone, and welcome to our Hunt and Hunt lunchtime webinar on wage theft and modern slavery. I can see some people have joined. Thanks for attending. Let's just give it a little bit more time to allow everyone else to jump on, and then we can get started on presenting this webinar today. Okay. I hope everyone's able to see my shared screen for today's presentation. So it's titled Wage Theft and Modern Slavery. If you can't, please let me know and we'll get that sorted straight away. Okay, so let's kickstart today. Thanks everyone for attending. For those of you who may not know me, my name is Joey Tass, and I'm a senior associate within Hunt and Hunt's litigation team, and I practice predominantly in litigation from its Sydney office. Joined with me today is Dr. Stephen Morse, CEO of Unchained Solutions. Hi, Stephen.
Joey, how you going? It's great to be here.
Good to have you here, and thank you for joining us today, Stephen.
Thank you. It's a real great privilege.
Okay, so I'll start with the agenda. So please note that today's webinar is being recorded, and we'll also be sending to you guys these slides along with the link of the recording. So if you're able to watch again, for those who have not attended today or you want to watch again following this session, please feel free to do so. We'll send you the link, the presentation, and the recording. So thanks. Now we have also allowed some time at the end to answer some questions, but if we don't get the opportunity to do so or answer all the questions, please feel free to get in touch either with myself or Stephen after the webinar. Email us, call us, we'll be happy to discuss anything further. So today, in the first half of today's webinar, I'll be talking about employment law, and more specifically, the particular topic of wage theft, which is an ever-increasing topic in today's society, as undoubtedly some of you guys may be aware about. There's various legislations being implemented, criminalisation of wage theft. So it is a topic that has slowly but more recently gained much traction. And then following my part, Stephen will be talking about, Stephen will be taking over in the second half of the webinar, and he'll be talking about modern slavery, what it is, risks and compliance from a business perspective. Okay, so the Fair Work Act is a piece of legislation that regulates the employment relationship for most employees within Australia. It is the foundation of all minimum standards and regulations for employment that falls within the national workplace system, being predominantly the private sector. So just take note that some employees do fall under state-based legislation, which is not covered in today's presentation. So it's more so the private sector organisations that we're dealing that I'm discussing, going both ways in relation to employers and employees. The provisions within the Fair Work Act, which is a legislation that governs the private sector with respect to employment, this piece of legislation is important, and it is the central piece of legislation that caters for many things. So it provides the terms and conditions of employment. It sets out the rights and responsibilities of employees, employers, organisations in relation to employment, and it also provides for compliance and enforcement, administration, and it also confers powers on other bodies to handle disputes and complaints. So the Fair Work Act, in short, as you can see on the slide, provides employees with a guaranteed safety net of fair, relevant, and enforceable minimum terms and conditions through the national employment standards, which is within the legislation. And then it's also, in addition to that, creates modern awards and national minimum wage orders. So currently, there are 11 safety nets and minimum entitlements, which are mandatory for all employees, regardless of their industry size, regardless of their industry or business size, or any other particular aspects. These 7 safety nets are an absolute minimum, and they cover things such as your maximum weekly hours, which is currently 38 hours, unless it can be reasonably argued that in addition to that, more than 38 hours are required. And these are various things that take into account, such as the nature of the industry, whether you're getting paid penalty rates or additional remuneration for it, impact on your work health and safety. So, but it does set out that there are 38 maximum weekly hours of work, ordinary hours of work for employees. Also touches things upon the right to request flexible working arrangements if you need to care for a child or have care responsibilities and the like. Also things such as various leave entitlements, such as parental leave, personal and carers, community leave, annual and long service leave. Also touches upon your public holidays. Do you get paid for those? Do you not? Do you have the right to refuse working on a public holiday? And then finally, legislation deals with termination, your notice periods, redundancy pay, and the like. So now, whilst the national employment standards, these 11 that I've just discussed very briefly, provide a base level of provisions which are applicable to all employees in the national workplace system, most minimum entitlements for wages and employment conditions are also found in modern awards or registered agreements, which provide additional enforceable employments for specific job roles within both the industry and occupations that they cover, relating to, for example, minimum wages, penalty rates, rest breaks, classifications, allowances, various different allowances, and as well as procedures for consultation, representation, dispute resolution. All of these are very, very important, both from just a general employment setting, as things that need to be met and processes that need to be done before any sort of decision is made, or in relation to ensuring people are being paid the correct rates. But it also touches upon wage theft when, you've got people that are classified wrong and being paid, a rate lesser than what they should be paid, which is determined by their job description. But yeah, so whilst I said the national employment standards set the minimum terms, there are also modern awards and registered agreements that apply to industries as well, which people and organizations need to be aware of. So there are, of course, other legislations that cross over with the Fair Work Act framework, such as the Corporations Act and the Privacy Act. So they all interrelate. And in addition to that, the Fair Work Ombudsman and the Fair Work Commission are the 2 key regulatory bodies responsible in administering the Fair Work Act system. So in relation to the Fair Work Ombudsman, this is an independent statutory office with the primary responsibility for promoting and monitoring compliance within the Fair Work Act and any associated instruments. Now, to achieve this, the Fair Work Ombudsman's functions broadly include things such as providing education, assistance and advice to employees, employers, FIFO workers, and their employing organisations. It also helps promote and monitor compliance within workplace laws. The Fair Work Ombudsman investigates breaches of the Fair Work Act, and they also take appropriate enforcement action where possible. In addition to that, there's also the Fair Work Commission, which is Australia's National Relations Tribunal. Its functions and powers predominantly include setting the national minimum wage and wages in modern awards, which happens every year. So that's set every year, and they take into account various things such as inflation, CPI, and other factors, and then make a determination and set those rates every year. Now, the Fair Work Commission also makes reviews and varies modern awards depending on whatever the scenario may be. They also do 4 yearly reviews and make any necessary changes as they arise. The Fair Work Act also facilitates the bargaining and making of enterprise agreements. It also deals with general protections, unlawful termination of employment, anti-bullying claims, and unfair dismissal claims. So this is more the dispute side from an employment setting where there's been a dismissal or allegations of bullying behaviour and the like. The Fair Work Commission also issues orders to cease or suspend industrial action, and then it also determines applications for right of entry permits, which is generally happens when unions get involved and things like that. And also the Fair Work Act resolves collective and individual workplace disputes through alternative dispute resolution procedures. So to the interesting part, what is wage theft? Now, wage theft on a broad scale is a relatively new phenomenon, and it creates significant problems for Australian labour market regulation. Currently, there is no consistent working definition of wage theft. Other terms, including underpayment and exploitation, are also often used to describe behaviour by employers that amounts to wage theft. Broadly speaking, wage theft is defined as paying workers less than they are entitled to under Australian workplace relations system. So its various forms include underpaying wages, not paying the correct penalty rates or at all, not paying superannuation or paying the wrong superannuation percentage or the guaranteed. No, it's 10.5% now. But there are various organisations, especially those that don't have, or don't seek the legal advice, that may potentially be paying, a lesser rate if they haven't, got the right advice or up to date with superannuation guarantee changes. It includes non-payment of overtime, non-payment of commissions, or other entitlements such as sick leave, annual leave, or carers leave, or requiring workers to repay money earned or making unauthorised deductions from from employee pay. Now, a big misconception is, if there is an agreement in relation to a deduction between an employer and employee, then people think that's okay. But the legislation is strict in that sense, and there are only some permitted circumstances in which a deduction can be made between an employee and an employer. Even if there is an agreement, if there is an agreement between the two, if the legislation does not permit it, then realistically, if we're looking at the letter of the law, it's a deduction that's not permitted. So there are various different circumstances in which wage theft can be classified and in which it can occur, which makes the whole notion of wage theft quite complex. And unfortunately, in addition to all of this, in many industries, underpayment is deliberate and systematic and often normalised, especially for your migrant workers, which I'll touch upon shortly, and will be further expanded by Stephen later in his webinar. But it is an area of law in the employment space, which is there are high profile cases, and it is an area that is more prevalent in these days, given to the extent that things are happening. So as I touched upon, the extent of wage theft is quite alarming. So in 2020-21, the Fair Work Ombudsman conducted an audit and found that there was 81% non-compliance across just under 700 workplaces in relation to underpayment, failure to keep adequate records, and payslip non-compliance. Now, the Fair Work Act also in 2020-2021 completed just under 18,500 disputes, and they recovered approximately just under $150 million on behalf of nearly 70,000 workers. Now, for vulnerable workers, the proportion of workers affected by wage theft is higher. So, for example, the 2017 wage theft in Australia report, which surveyed approximately 4,000 migrant workers, found that about 33% of those surveyed received around half of the minimum pay to which they were entitled to. Half. So that, those numbers are quite alarming. And as you can see, and as I sort of just briefly touched upon, despite wage theft being, affecting all employees in various different forms and in various different ways, those that are more vulnerable, your migrant workers, your younger workers, are a higher proportion when it comes to wage theft. Okay. So deliberate underpayment is usually common in industries which are labour intensive, have a high proportion of unskilled workers, and in which insecure employment arrangements are common. So often these industries have low levels of union membership, and they tend to employ a high proportion of workers on temporary visas or undocumented migrants. So they also lend themselves to fragmented value chains, which make it possible to obscure who profits from underpayment. For example, labour supply arrangements featuring outsourcing, subcontracting, or labour hire operators, which are notorious in this area of wage theft. So what are the categories of wage theft? Well, the most blatant form of deliberate wage theft is non-payment. That is when the worker is simply not paid any wages at all. There are also other forms of non-payment or underpayment which exist, and these include, and I'll touch upon now, things such as non or underpayment of allowances and additional rates, which is the most common form of deliberate underpayment, and it includes the non-payment or underpayment of overtime, casual loadings, and penalty rates. Also, making payment below the minimum wage or applicable awards. This is important, and what I find is a lot of organisations don't necessarily have the appreciation as to what relevant award applies to this specific employee or the applicable rate. They may work off what they think the market rate is, which sometimes is below what an award would classify a certain individual subject, depending on their work experience or their qualifications. There's also misclassification. So, this is a situation where workers are paid at permanent rates instead of casual rates, or where workers are misclassified as trainees so that they can be paid at a lower rate, where they start as a trainee, they progress, but their rate doesn't change, or where workers are paid at one level of an award but are expected to complete duties at a higher level, which would attract a higher pay. There's also, falsification of records. In some cases, employers have falsified the number of hours worked by employees to misrepresent them being paid at higher rates of pay that they should actually be receiving. There's also cash in hand employment arrangements. This is characterized by lack of employment paperwork, no pay slips, no employer income statements, below minimum rates, lack of superannuation payments and the like. So it makes it hard in those sort of circumstances to determine, or to be on a good foot in relation to seeking your minimum entitlements being paid when there's, lack of record keeping. Another one is the expectation to complete unpaid work. For example, working additional time to set up or close down a job, attending training, completing administrative tasks where insufficient paid time has been allowed for that work to be completed. Sometimes travel time where this is integral to the work, where rest breaks aren't provided. For those who may not be aware, McDonald's currently has a class action in excess of $250 million as we speak on account of its employees being denied paid breaks. Again, who are these employees? And as I touched upon, they're your younger employees that ordinarily, don't know precisely their full entitlements and are less to speak up or to demand, their minimum rights. And then there's also, like I said, your non-payment of superannuation, where employees don't pay the minimum superannuation guarantee contributions, despite, in some cases, contributions being shown on payslips. And then there's things like, ending of employment, where workers, may lose unpaid wages when they are made redundant. A business ceases, or where there's an insolvency, which is strategically used to avoid paying workers. And, lastly, sham contracting arrangements, where workers are required to register an ABN and get paid under that, where they miss out on your leave entitlements, where in all practical sense, they're actually an employee and should be receiving these leave entitlements. So the most common type of self-reported underpayments have been where an employment contract has defined a total salary, your annual remuneration, and it has later been found out not to have paid as much as if the worker had stayed on the relevant award and had been paid per hour, with additional hours paid at higher rates, or as overtime or other penalty rates are incurred. So what I mean by this is, if a modern award applies, that's great. And sometimes to avoid, the lengthy process of paying as per the award, as per the hours worked by a specific employee, which may range from, week to week, or the overtime, which may range from week to week, or the penalty rates or whatnot, employers opt in to pay an annualized wage arrangement. So they say, okay, well, under the relevant award or under the relevant award, it says your rate is, $24 as the minimum rate for your classification. Then they'll, do a calculation which says, okay, well, assuming you work, 38 hours a week, at the $25 full-time salary, they'll pluck out a figure and it'll be, say, call it, $70,000 for argument's sake. And that's what they'll work off. But the problem will be is that in these instances, unless it's revisited each year, or the organization has an appreciation of any wage increases, or a proper understanding of the actual work this employee does, the hours they work, any overtime, any penalty rates, any public holidays and things like that, what we increasingly find with a lot of our businesses, clients that we act for, is that they've actually underpaid their staff when they haven't revisited the situation, usually on a yearly basis, or they've underestimated the work that they've been doing or the hours that they're doing. And realistically, when you're applying the minimum wages and the minimum rates and the minimum entitlements that these employees should be getting paid, they've underpaid. And that's the simple point of all of this is that you need to appreciate and understand precisely the entitlements that you should be paying your staff. And that's what I say in relation to employment law, is that it's not set and forget. Just because an employer may pay the minimum award rates for any year, if they don't regularly do a health check, is sort of how I phrase it, of the applicable rates and the spread of hours, and the nature of the work, and the days that any given employee is working and undertaking, and also their experience and their qualifications. They may do a diploma or certificate for, or whatever the case may be. If they're not understanding all of this, It's very easy for an employer to get caught out, underpay their staff in a, outside of the minimum rates or entitlements expected, and be liable for an underpayment claim. Other forms of underpayment to which workers have been subject may not be unlawful, and they include where there's an enterprise agreement that's been found to be invalid. So it would not have been illegal for the employer to pay according to the agreement that was registered at the time, but later on it's been found to be invalid. Or, for example, where there's legacy agreements or zombie agreements that are still in force and may result in very low but not unlawful rates of pay. It's also where enterprise agreements that have passed, their normal expiry date but have not been terminated. So there's that situation, and there's also the situation where employees are not covered by modern award or enterprise agreement, and in those circumstances, it would be a situation where they're getting paid less than the minimum wages that are set by the legislation. There are a number of barriers which exist that give rise to wage theft and inaction and legal remedies being sought by workers. So in many instances, it can be, a David and Goliath contest where employees choose not to proceed against well-resourced corporate entities. Generally, various barriers, include things such as your lack of awareness or education, your lack of confidence. So it may impede workers from taking action because they believe it's too onerous, the amount of unpaid wages is insignificant, or because of their ability to understand or navigate complex rules and procedures. It includes mistrust, and fear of anything happening if you pursue your employer in respect of an underpayment claim. They don't want to raise this with their employer and then potentially be out of a job. Insufficient evidence, high costs in recovery. So costs, from filing fees, court fees, lawyer fees, especially if the employee is seeking a remedy, which, they're seeking amount that they've been underpaid, that they have been underpaid, which will be outweighed by the legal costs and other associated costs associated to recover this amount. And the inability to take action sometimes. So temporary migrant workers may have insufficient time to initiate action because of time limits on their visa or, things like that. There have been many high-profile cases of wage theft, which shows that the exploitation of workers is widespread, rather than limited to a specific sector or portion of the workforce. So examples include, Bupa has underpaid approximately 18,000 of its current and former staff by as much as $75 million since 2014. Coles, on December 1, the Fair Work Ombudsman commenced federal court proceedings, claiming that underpayments between 2017 and 2020 totaled approximately $115 million. Qantas has self-disclosed the underpayment of approximately 600 odd employees over 8 years, totaling $7 million. So, there are many more high-profile cases involving other large organisations, which goes back to show that any organisation is at risk of wage theft if they don't have the proper protocols and proper procedures in place and methods to ensure that they are paying their employees their correct entitlements. Now, some options that may be available to an employee who believes they have been underpaid include, firstly, common logic, seeking to address it informally by discussing it with your employer, or alternatively, through a union representative. Now, this may quickly resolve matters, although I do appreciate sometimes there may be barriers and it's not the most effective option. Alternatively, you can lodge a complaint with the Fair Work Ombudsman, who has powers to investigate matters. This would be the most cost-effective option because making a complaint with the Fair Work Ombudsman, assuming they accept it and look into the matter for you, is free of charge. So there's no sort of legals or other fees associated because this is an obligation of the Fair Work Ombudsman. So that is, again, the most cost-effective option at the first instance. Alternatively, pursuing legal proceedings, in the appropriate state or federal court, including the small claims division. The benefits of making a small claims application includes that it's less formal, faster, less expensive, although it's important to note that penalties will not be imposed on employers, if they're found to have breached any legislation or awards or whatnot in underpaying staff in the small claims division, which is claims for less than $20,000. And if the amount is more than $20,000, then again, the relevant state federal courts have jurisdiction. And it's important to note that underpayment claims have a 6-year limitation period. So you can only claw back for the last 6 years. And if it's superannuation related, you can lodge a complaint with the Australian Taxation Office. Just over to my last slide before Stephen starts his part. And I just wanted to briefly touch upon the wage theft criminalisation. So 2 states have gone that extra step to criminalise wage theft, first being Queensland and then Victoria. Both states have criminalised wage theft to attract significant monetary penalties, as well as up to 10 years imprisonment. Other states are yet to follow, but as happens all the time, they slowly do follow either to the same extent or loosely similar. But the 2 states that have actually enacted legislation to criminalise wage theft currently, like I said, are Queensland and Victoria. Now, the central notion or the central idea in the criminalisation of the wage theft for Queensland and Victoria, at least, is that the criminal offence will only be applicable to those involved that have deliberately engaged in egregious conduct, which is, first of all, high threshold, along with the need to prove the offence to the criminal standard of proof beyond reasonable doubt. So what this basically means is that it would need to be conduct systematically done with the intent to engage in wage theft to minimise or not pay the correct rates or entitlements. And it does not include situations of honest mistakes or mere errors by the relevant individual within the organisation. And it can be any individual within an organisation if they're implicit in it or have contributed to the wage theft. So overall, the overriding message here today, from my perspective, from an employment law and in respect of wage theft, is that employment law is not, again, it's not set and forget. Engaging employees and paying their entitlements is not straightforward, and it requires careful consideration of various components. And it's important to revisit, employee agreements, employee engagement, and wages and entitlements and the like, on a year basis. The relevant instruments that govern an employee's entitlements, such as your modern awards, your enterprise agreements and the like, are not an easy read. And employers who fail to be proactive and manage the terms of these engagements for their employees can be exposed and risk being in breach of the law and penalised. We've seen it happen often and many times, from your small mum and dad sort of businesses and organisations, to your large corporations. Both have been caught out, which goes to show, irrespective of the advice that you seek, and obviously large corporations have their own in-house teams and legal teams and lawyers and whatnot. Beside the point. The point is that from an employment perspective and as an organisation, you need to be proactive and understand all these various aspects and know the law, and obviously seek the appropriate legal advice, to avoid getting in these sort of nasty and sticky situations. So that concludes my part. Over to you, Stephen. Thank you.
Great. Thanks, Joey. Thanks for those insights. They're absolutely relevant and spot on, and very dovetail into what we're going to now move on to, which are, I suppose, more grievous human rights violations, and in particular, the issue of modern slavery. Just wanted to begin with a recent story of the arrest of an oil tanker, AG Neptune, which happened off the coast of New South Wales at the port of Newcastle back in May. And it was originally stopped at the port of Gladstone in Queensland due to a concern around the contamination to the oil. The oil was owned by Viva Energy, and the ship was being chartered by Vital, which is a UK-based controller. And unfortunately, what this incident highlighted was that it was actually but only when the ship got to the port of Newcastle that it was discovered that there were a number of seamen on board, 21 sailors in fact, who were suffering all sorts of conditions that contravene Maritime Labour Convention, who were being collectively owed about 123,000 Australian dollars. And there was evidence there of lack of appropriate accommodation, food and water, and also a lack of attention around healthcare for these workers. As a result, the ship has been banned from Australian waters for 6 months, and it's the first time that the AMSA has hit a ship with such orders this year. I share this story as a way into this discussion because this ship is associated, not a supplier of one of my clients, but Viva Energy certainly is, and it really just highlights some of the complexities and the extents to which issues around forced labour and modern slavery occur at different touch points in the supply of goods and services. This incident had nothing in particular to do with my client, but it actually showed the importance of making sure there were adequate inspections and vetting processes. And it does raise the question as to whether those who were in charge of, in terms of the shipment of this or of this energy, had actually done the appropriate checks and balances. Another story, just quickly, has to do with a case that's now going on in the United States regarding Ansell and Kimberly-Clark over the exploitation of Bangladeshi workers in factories in Malaysia. The issue around the production of PPE and risks of human rights violations was highlighted during the COVID era period, where there was a relaxation of regulations around the production of rubber gloves, and other PPE, simply because of the great need and the demand for these products. And so what we can say in terms of global markets is where there is a demand, it's interesting to note that there can be a laxation in terms of regulation. And we need to be mindful of that in terms of then the impact of particularly migrants who get caught up in cycles of exploitation. Today, I just want to run quickly through the risk of modern slavery and the impact of the legislation, in particular the Modern Slavery Act 2018 at a Commonwealth level. And then I just want to run quickly through some keys to compliance and things that I'd like you to take note of, and then a little bit, if we have time, about Unchained. So the Unseen UK says that modern slavery is the commodification of people for the purpose of exploitation and financial gain. So when we're thinking about issues around modern slavery and what they're about, we're really looking at the entire global economy and how some people profit off others' exploitation, for example, and human rights violations. And so really modern slavery is very much in a commercial sense, very much part of the commercial global economy of how things operate in our world. And there are many, many businesses involved. At a united nature, at an acute level, modern slavery is simply the lack of or the removal of choice, movement, and voice. And so at an most acute level, that's what slavery is about. But the term has also been used both here in Australia and in the United Kingdom as an umbrella term to describe a range of human rights violations of a similar category, similar nature, including forced labour, forced servitude, debt bondage, extreme forms of child labour, forced marriage, and human trafficking. This list is not exclusive. There are other forms of modern slavery that are not included under this rubric, but for the purpose of the legislation and how it actually applies to Australian organisations, particularly corporations, these violations have been included in the terms. It's very difficult, and due to the complexity of modern slavery, we've just touched on the complexities around wage theft, but that's kind of at the top end, if you like. It gets even more complex as we go down. So we do have issues of wage theft to the point of low pay or no pay, all sorts of indicators, including excessive work hours, recruitment fees, people having to pay money, and in a sense at times borrow money to pay money to get a job in another jurisdiction. There could be a lack of a contract or a zombie contract or some sort of shoddy arrangement around their employment conditions. The loss of identity with passports and other papers taken, fines for all sorts of indiscretions. And really, we can also see, there's an unsafe workplace. There could be unsafe machinery, or the air quality, or the water quality, or the waste management. And this is often where modern slavery intersects with environmental concerns. Factories which are pumping out all sorts of fumes or not managing their waste and toxins going into rivers. These are the kind of places where there is the risk of modern slavery. And of course, there's all sorts of psychological concerns around coercion and threats and intimidation. And from our perspective at Unchained, we see that the greater the cluster of these indicators, the greater the risk, if you like, or the potential for the case of modern slavery. Because any of these by themselves is not a case of modern slavery per se, it's actually when we group these together. In terms of the scope and the numbers, you may have heard some big numbers. Well, it's according to the International Labour Organization, we're now up to 50 million people caught up in forms of forced labor and forced marriage. That's up from 40 million, say, in the last 10 to 12 years. Still 1 in 4 are children, and a great proportion of people exploited are women and girls. The biggest category is forced labor, where we have around 61%. And of course, it's a multi-billion-dollar industry involving organized crime and money laundering and all sorts of financial issues attached to this issue. In Australia, we still have a lack of clear evidence of what the real numbers are. The Global Slavery Index put it around 15,000 cases in Australia back in 2018. But what we can say is there's probably around, for every 1 in 5 cases are reported. So 80% of cases in Australia are not reported. And that could to do with the range of issues identified earlier by Joey. People don't want to say anything. They might be on a visa condition where they don't want to speak out, or they don't know where to go to get assistance for this issue. Some key areas of risk you may have known in the terms of the high consumables around chocolate and coffee and the textile industry, the apparel industry. More recently, there's been a great focus on fisheries, particularly off the coast of Thailand, with many cases of young men being caught up on fishing boats for months, if not years at a time, and being moved from boat to boat until they're completely depleted and exhausted, and then tossed and discarded because they're of no use to anyone. There are many organizations that are addressing this, particularly Thai Union in Thailand, one of the largest producers of tuna and seafood in Thailand. So there's a lot of work being done in all these areas. The chocolatiers are committed collectively as well as individually to setting up programs. And there's also been a lot of work to work out how we can unpack the complex and long supply chain of the textile industry. But for those, we could also say that modern slavery intersects with many industries and many products, including agriculture and mining, services, fashion, medical supplies, construction, a whole range of food production, the logistics and transport, as I noted at the beginning. There's also been a lot of risk around information technology and particularly around the harvesting of minerals that go into technology and also that go into electric vehicles. So there's a lot of attention being focused on particularly exploitation in the Democratic Republic of Congo of child exploitation for lots of minerals that go into the technologies that we enjoy, and we're pumping into environmental products. So this is where modern slavery needs to intersect with the big brother environmental, and that needs to be a lot more attention given to what we're doing to be green, but we need to make sure that we're doing the right thing in terms of human rights. Risks in Australia are very similar, although to an extent some of the largest risks here have to do with agriculture, particularly the horticulture sector and the harvest time of the fruit. This is where we see a lot of people coming to Australia from the Pacific Islands, seasonal workers, backpackers, who get exploited and suffer all sorts of privations, as noted earlier by Joey. to the extent that some are actually in much more severe and graver forms of exploitation. It's been noted that forced marriage is a big issue in Australia, and there are thousands of women and girls who get caught up in cycles of forced marriage here. And there's also been a lot of work done to address and note risks in cleaning services, retail services like nail salons, car washes, as well as the construction industry and security industries as well. So we have risks here in Australia. A lot of it is unfortunately anecdotal, and a lot of work needs to be done to actually clarify what we're looking at. But there's also some great work being done by NGOs to address some of the issues and to work to provide services to support those at risk in Australia. When it comes to the actual legislation, the Modern Slavery Act, as I mentioned earlier, is really kind of an expression of, a hard expression of soft legislation that's been developed internationally over the last 20 years, particularly the United Nations Sustainable Development Goals and the UN Guiding Principles on Business and Human Rights. And these kinds of soft laws at an international level are really finding their expression in local hard laws. And this one here, the Modern Slavery Act, has been put in place to work, in a sense, on top of sort of crime legislation, because the slavery is officially illegal in Australia. But this kind of legislation is really targeting organisations and companies to help them to identify risks and criminal activity in the supply of goods and services, most of which come from overseas in Southeast Asia. And really what the legislation is asking organisations to do is two key words, really. It's about being transparent. So identifying where the risks are and putting resources into the identification and being transparent about that. And that has implied risks itself, as well as to then take steps to be responsible for those actions. So transparency and responsibility. And those who need to report into this legislation are those who have an annual consolidated revenue of over 100 million. And they need to report in on an annual basis, depending on their financial year structure, what actions they've taken to identify risk and what they're doing to take responsibility. This slide here just shows there are 7 areas of criteria, and I won't go through them in detail, but of note, if you look at 3, 4, these are sort of the main this is the engine room of the reporting mechanism to describe the risks of modern slavery practices and then to describe the actions taken. An area that organisations struggle to do very well at this stage is around 5, around the process for assessing the effectiveness of those actions. So impact measurement in this space is lacking, and many organisations are still trying to work out actually what that looks like for their organisation. At this stage, the legislation is going through a consultation process for review. So the Modern Slavery Act at a Commonwealth level is going back into Parliament early next year. And there are many reports and recommendations being made with an end date of, I think, at the end of November. At this stage, the Act really asks organisations to take reasonable steps. And this can be obviously open to interpretation. It's probably one of the areas of weakness in the legislation because it's allowed organisations to then choose their own adventure, to do their journey and to work out what's actually going to work for them. And that is, in a sense, put the emphasis on the market and emphasis on businesses to sort themselves out. And so while we have many shining examples of great work that's been done in this space, there really has been a race to the middle. And so a lot of sort of part of this consultation process is actually trying to work out how can we not just make it about reasonable steps, but what kind of steps actually do companies need to take? And what is maybe a little stronger, more of a prescription of what organisations should be doing, perhaps even 2 to 3 years down the track. One of the challenges and the complexity of modern slavery comes from a quote from Nolan and Bersma in 2019, in the sense that modern slavery sits on a continuum of exploitation, and it should not and cannot be addressed in isolation. In our bid to manage, reduce, eliminate modern slavery risk, we need to first acknowledge the larger contextual problems from which it emerges, and we should treat the symptoms and the causes. And so that's where we need to kind of look at the bigger picture and really try to get to understand the complexities and the specificity of modern slavery risks. One of the challenges for many organisations at the moment is that some organisations have been very good at setting up very elaborate or augmenting very elaborate risk management frameworks, policy portfolios, providing some awareness training for staff, doing an initial foundational assessment of risk for those suppliers that they buy directly from, However, more work needs to be done to drill down into that supply chain to get to the level of manufacturing, and furthermore to get down to the level of where the raw materials, and to do that collaboratively, to do that in conjunction with governments, to do that into conjunction with NGOs and those who have expertise on the ground. That's where we're going to get greater visibility and understanding and true transparency. And so of recent, over the last 12 months, there have been some reports come out. A lot of research has been done into the corporate response, and some of that work's been done by us at Unchained in partnership with Macquarie University and the Macquarie Business School. And there's been lots of interest in terms of to see what organizations are saying about themselves. And so we've, some key themes which we've already identified. There's been a lack of supplier risk assessment beyond direct suppliers, those who they buy from in Australia. A lack of stakeholder engagement for building capacity. So been a lot of activity which has just been issuing, say, an SAQ, a self-assessment questionnaire to a supplier without appropriate engagement, collaboration, training, and capacity building. A lack of a clear remediation strategy, apart from what we can say theoretically, and part of this has to do with the lack of stakeholder engagement, and a lack of clear metrics to measure effectiveness. So what are the keys to compliance? Well, I have a lot of it in my own engagement with the private sector. There's a range of responses, and there are really two key issues for organisations that they really need to overcome in order to move forward with the legislation. One has to do with appetite. There needs to be a growing appetite for actually doing this kind of work, along with other ESG reporting work. The ESG space can easily be seen as a buzzword, and there are lots of issues that organisations need to be focusing on, and modern slavery is just one of them. But for really to be agile in this ESG reporting world, there needs to have a really strong appetite, particularly at a board level. And a second to that is capacity. Organisations, I have time and time again come into contact with organisations that really don't have the internal capacity, or they don't actually fully understand what the implications of the modern slavery are for their organisation in terms of the allocation of resources in the long term. So when we come to this issue, I'll just move on to, I'll stay there, that's fine. So when it comes to this issue, then we really need to be thinking through setting appropriate goals, making sure that there's appropriate board engagement, and that the board of directors have a very clear understanding of their reporting requirements, particularly signing off on the report, on the statement. There needs to be very clear executive sponsorship of a working group, of a steering committee that actually can drive the legislation through the organisation, to then identify with the gaps within the organisation and what is already in place that can actually be utilised and augmented to actually do the work. A lot of the work that needs to happen in the first place is at the foundation level. And so on the one sense, it's nothing wrong with getting the risk management framework in place, getting the policies up to date, getting mapping out that direct supply chain. That's all very foundational and very important in order to then identify and segment where we need to go next, and how can we do that more strategically, more effectively over the long term, because the issue of modern slavery is not going to be resolved overnight. So two things to organisations to think about are appetite for change, along with other ESG indicators, as well as working out how they can have the capacity to do that and where they might need to outsource. And of course, there's lots of risks, unknown risks that organisations need to consider, but also opportunities. They need to, addressing this issue will mitigate potential financial and legal and reputational risks. There's also the issue of profitability and sustainability and resilience, that in order to develop resilient supply chains and businesses, we need to actually see quality as a bigger category, which entails human rights due diligence. And finally, then there's employee satisfaction and retention, which as we have a greater emphasis on purpose-driven businesses, this is actually important for us. So just in terms of who we are at Unchained, we are here to inspire Australian organisations to be leaders and making an impact on modern slavery. And we actually are committed to working with organizations to implement this act, because we see it as a great vehicle for doing due diligence, not just with this human rights violation, but with other ESG reporting indicators. We see it, we are a social impact, a social enterprise in the sense that we provide, give a portion of our products, of our profits, to those organizations that are working directly with people at risk, or those who have been coming out of a sphere of exploitation. And we do that through the Freedom Business Alliance as our preferred social impact partner. We come to this issue through the lens of a lived experience, with me and my wife and many of the team having some lived experience of working in the humanitarian space. So for us, this is not a theoretical issue. And we've combined that with the knowledge and tools and expertise to actually assist organizations through a range of solutions. Our solutions are around strategy, analysis, training, documents, and research. So we can meet with you and wrap our solution types around your particular needs of your organization and level of maturity. So yeah, if you'd like to connect with us, please do so. We'd love to talk with you about your needs and how we can support you with this piece of compliance. Thanks, Joey.
Thanks, Stephen, and thanks for sharing your knowledge and providing us more information about what you do in relation to modern slavery. So, look, if you're an organisation or an employee that requires any specific advice, please feel free to reach out to either, Sarah Capello, our litigation partner, or myself, or Stephen, if it's in relation to modern slavery. We've provided our contact details, so they're there for you. Either of us are all happy to talk through any issues and answer any questions you may have. I can confirm, in my approach is that it's, very much taking the time to truly understand, my client's needs in order to provide the most practical and beneficial solutions, which is a case-by-case scenario depending on the specific client. So we've got a little bit of time. I've got one question here, so I'm just going to go through that. Oh, sorry, just 1 second. No, so that's all good. Right, so look, I'm just next slide here. I'm just going to briefly, there we go, mention our next upcoming webinar on the 9th of November, where Sarah Capello and Georgette Georges of Hunt & Hunt Lawyers will be doing a session on trademarking and the importance and benefits in registering trademarks for businesses. Also, if you want to keep up to date with some of the legal updates, webinars and information that we do send out, you can subscribe to our newsletter through the link that we have provided. We try to be proactive and generous with our time in sharing of information with both our clients, referrers, contacts, and the community at large. So, look, thank you everyone for your time today. Both Stephen and I hope that you have obtained some value and benefit from today's webinar. And please do reach out to us if you have any questions, and we'll be happy to help. Have a great day, and thank you, Stephen, for joining today.
Thanks, Joe. It's been great. Really appreciate it.
Thank you. Take care, guys. See ya.